you. And with Anthony and Randy not being here to introduce myself, that's great because I can do a very brief introduction. My name is Ira Packer. I'm a Professor Emeritus of Psychiatry at UMass Medical School. And I've been a forensic psychologist for many, many years. The work I'm going to be talking about competence to stand trial evaluations is based to a fairly significant extent on work that I've done with my colleagues at Groundswell Inc. And it's a consulting group, and that is Neil Gowen-Smith. I'm sure everyone knows these people. Daniel Murray, Lauren Coyce, Virginia Barbarioja has joined us in this. And we've been doing some consulting to a number of states, but also I've asked for my colleagues from ABPP for their guidance about what's going on in their states. So you'll see that I have some slides from various states. None of this is comprehensive. I did not do a full 50-state deep dive into what everyone's doing. But what I did do is ask for samples, and I'm going to try to discuss the more general issue here of what is the role of forensic evaluators in assessing competency in light of the current status, which means now there is much more concern, not just about is the person competent or not. Is this somebody who needs to be in a psychiatric hospital? If not, is there some other way of managing this case? And this is really all stemming from, as we'll see, this enormous increase in referrals to state hospital beds. Okay, so let me move on. I have no conflicts of interest. We don't need the CE, and do not have a financial arrangement related to the content of this activity. Oh, and the last one was, the views expressed in this presentation are those of mine and do not necessarily represent the views, policies, and positions of the University of New Mexico. I know that's standard, but it probably has some more poignance here because one of the things, obviously what I'm talking about are the various statutory changes and different new requirements for forensic evaluators in terms of how they do these evaluations. And I know that some of that is controversial. I do want to say that most of the controversy probably has nothing to do with me and has to do with people's reactions to the new requirements for them. But I think it's particularly important. This doesn't reflect New Mexico. So just very briefly, I'm assuming, I'm looking at the number of people here. I assume many people here are forensic evaluators or administrators in public systems. And so you all know this, but just to put it in context, over the past 20 years or so, most states, and it's getting to be almost all, have been overwhelmed by an increase in defendants who are found IST and ordered into state hospitals for restoration. Okay. What's interesting is not only has there been an increase in the number of defendants who are being referred for evaluation of competence to stand trial, but also a significant increase in the percentage of those found IST, incompetent to stand trial. So you've got a double whammy here. Many, many more people are being referred for evaluation, and then a higher percentage of those are being adjudicated as incompetent and then referred into a state hospital. And the state hospitals simply don't have the capacity to manage all of these individuals. This has created not only enormous pressure on the hospitals and on the state administrators, but a number of class action lawsuits. And this is just a sample. This is not comprehensive. There's Washington State, California, Oregon, Texas, Pennsylvania. New York is now in the process of one. So this is something that is really pretty much wide across the country. I will say that up until recently, I am from Massachusetts. I'm emeritus, so I'm no longer involved, but for many years, I was involved in the forensic system in Massachusetts, and I like to go around the country kind of pointing out that we did not have a wait list. People who were arrested were evaluated at a court clinic at the time of arraignment. Literally that day, they never go to jail. They would go straight to the state hospital if there was a question of competency. I've been gone for 4 years, but I've been told that nowadays Massachusetts also has a wait list, and it's starting to get bigger and bigger. So this is really a national problem. So what have some states tried to do? Obviously, the simplest one is increasing inpatient capacity, and that has limited effectiveness simply because if you build it, they will come. And so just adding more beds usually doesn't solve the problem. I do want to acknowledge that there was an issue during COVID, of course, where there was a reduction in beds because of all sorts of issues, both safety of the individuals and also difficulty finding staff. That has started to rebound. So there is a little bit of increased inpatient capacity just, due to COVID receding, but there's still a certain amount of additional bed capacity that some states are starting to build, but building new beds, it can't be the only solution to this problem. Some other are creative alternatives, restoration sites, either outpatient or jail-based. And I know there's some controversy about jail-based restoration, and that's not a focus of what I'm going to talk about today, but at least it's something to acknowledge that one of the responses of states is to say, let's restore competency in places other than state hospitals. An even better plan is to divert people. If somebody really does not need the crime isn't that serious and they really don't need to be put in a state hospital, they can be diverted not only from the state hospital, but from the criminal justice system. Okay? There's also some increasing attention on quality assurance of forensic reports, because obviously if there are reports where people are being referred inappropriately, let's say there's malingering that was not tested for, or somebody who has an acute intoxication, so they seem psychotic, and after a few days, they're back to baseline. If you can winnow out the inappropriate admissions, that also will help. That also helps to deal with the bed capacity. Improving mental health services in jails. Individuals who are treated in jails early on, they may not even be adjudicated incompetent, or if they are, they maybe can recompensate fairly quickly rather than have to wait for the months that many states are now having wait lists of months long. A very creative solution, and California deserves a lot of credit. I will tell you that they have really been on the forefront of some very innovative approaches to dealing with their wait list, and they've been very, very successful in doing so. One of those is they reevaluate individuals. So if individuals were waiting in the jail for a hospital bed, they reevaluate them, and this can result in discovering that some percentage are really now competent and don't need the bed. I'm not going to go into too much detail on that because that's beyond the scope, but anyone who's really interested really should be in touch with leadership in states that are doing such good work like California. The focus of this presentation, though, is what is the impact of all of this, these systemic issues on forensic evaluators? So most of us, and I've been doing it for a very long time, we're taught to focus only on the issue of competency and not necessarily clinical needs or treatment needs. Okay. In fact, I know that in some states, there was very clear guidelines that said you were only supposed to offer an opinion whether the person seemed competent or incompetent. You're not supposed to say whether they need hospitalization. That seems to be changing, okay, at a necessity. The crisis is so severe that unless you get an evaluator who is in the best position to do this, because who else? If the evaluator who's seeing this person doesn't at least opine on this issue, it's very difficult to, in a timely manner, get a second opinion on this. So that really has gotten us to rethink the role of the competency evaluator to go beyond just assessing competence to stand trial, but also to offer opinions on whether or not this person needs inpatient or outpatient restoration. And as we'll see, there's even some jurisdictions that ask for input on whether this person is an appropriate candidate for involuntary medication. We'll get to that more specifically. However, I do want to be really clear, and I'm going to come to this at the end again, because I don't want any of this to be interpreted as saying oh, we need to sort of go from our impartial role as forensic evaluators to advocates for patients, defendants, individuals that we're dealing with. There's still an important concept that we still need to be impartial. However, being impartial doesn't mean that we can't opine on some of these other issues. So let me just give you a few examples. And again, I just want to be very clear. You'll see that I have a number of states that either I know of personally, like Massachusetts, or that I've gotten from my colleagues who work in these jurisdictions, including from the American Academy of Forensic Psychology listserv, which is an unbelievable resource for those who are ABEP in forensic. You just can pick the minds of the most talented, skilled, knowledgeable forensic psychologists in the country. So I have a sample of some states. If the states aren't on here, it doesn't mean that they're not doing it. It just means I didn't get access to that. And I've really just picked a handful, really more to sort of exemplify some of the issues. And I want to say this very clearly because, you know, there's a lot of people here. I see 700 already. I'm not here to answer questions about a particular state. I can't comment on whether what any particular state is doing is good, bad, indifferent. I could just tell you what some of the issues are for that state. So if people do have questions about a specific state, you probably want to direct those to people who work in that jurisdiction. But let me give you an example of Massachusetts. So Massachusetts is a state, it's actually a commonwealth technically, that has a very interesting system. At the time of arraignment, literally the first time the person is brought to court, if an issue of competence is raised, an evaluation is conducted at the court. And all the major courts in Massachusetts have staff that are assigned to them. And if it's a small court, there'll be a satellite of the bigger court, right? Almost all of these evaluators are psychologists. That's ever since 1985 when the law changed. And there are maybe like 2 psychiatrists still left working in the system, but it is predominantly doctoral level psychologists who are highly trained and certified by the Department of Mental Health. And they do the evaluations at the court clinic. And really, those are screenings. What that means is they screen the individual. And if there is a doubt about competency, meaning they don't have to, they're not adjudicated as incompetent typically at that point in time. But if there's enough of an issue being raised about competency, the judge can order the person into a state psychiatric hospital for a more in-depth evaluation. Okay, so this is a case of AZ, and AZ was assessed as likely incompetent by a psychologist at one of the courts, and the judge ordered her to the state hospital under Section 15B for further evaluation. She appealed, and she said, hey, why am I being sent to the hospital? The judge should have really gone through an inquiry to determine if I really need hospital level of care. Is there any less restrictive alternative? And also, it should have required the judge to find that I pose a serious risk of harm to self or others, which is the commitment standard. So that was the claim by AZ. The Massachusetts court just partially agreed. They basically said the statute does not require evidence of risk of harm. Okay. However, because the state does have an interest in determining competency, it can be broader than risk of harm, but the judge should only order somebody into an inpatient facility if it is the least restrictive environment. Okay. And inpatient hospitalization can be justified as the least restrictive environment if, number one, the individual has a history of non-adherence with community treatment. So they're saying, well, we can't try and treat them in the community because they have a pattern of not following through. If they have a pattern of not appearing in court, because the judge is basically saying, I want them to be treated for competency, but return to court. And obviously risk can also be considered, but it is not a requirement. It's broader than risk, which is, I think, a very crucial point to think about, not only in Massachusetts, but more conceptually about what is it that necessitates or encourages use of inpatient facility versus some other way of restoring to competency. The court also said that expert testimony from a psychologist or psychiatrist, in other words, whoever did the evaluation at the court, could be used to help determine this need for inpatient or less restrictive alternative. And they used examples like the long-term observation as opposed to sporadic outpatient examination is necessary to adequately determine whether a defendant is competent to stand trial. So in other words, there may be good clinical reasons to justify inpatient short of risk, and that can include something as follows. What if the person is malingering? There's a question of malingering. The outpatient evaluator might say it's really difficult to tease that apart. In an outpatient setting, we think it's much simpler and more clear-cut to do so in an inpatient setting. That's an example. Or this is a very complex case. It requires full workup. It may require neuropsych, something that is not available in the community. So there are enough reasons why this can be done, but it really is a clinical decision. So here are some of the basic principles that are elucidated by this case. Evaluations of competence to stand trial should be conducted in the least restrictive placement. Risk can be one criterion, but it's not the only one. And there are other reasons why somebody could be sent in for evaluation, like unable to participate or appropriate programs are not available. And by the way, that last one is right for other kinds of lawsuits of people coming and saying, hey, sure, you're putting him in the hospital because there are no other programs, but you, the state agency, should be developing outpatient programs. But again, that goes beyond the scope of what we're talking about today. Now, I also want to be clear that, and as the next jurisdiction similarly, this is a situation where the person is not being sent into the hospital for restoration of competency. They're being sent in for an evaluation of their competency. However, I think the principles are going to be the same as you'll see when we get to states where the evaluation of competence is done either at the court or at the jail, and then the person goes into a hospital if appropriate. Washington, D.C. has a very similar model. They can be, a defendant can be ordered to St. Elizabeth's, which is their inpatient facility, for inpatient only if it's necessary that be in an inpatient facility to conduct an examination, or the defendant is unlikely to comply with an order for outpatient examination. So very similar to the situation in the case law in Massachusetts. And here is just a list of a few of the other states. These are states, most of whom we're talking about being sent into the hospital for restoration to competency, not just for an evaluation. If you see your state on there, great. If somebody knows you work in a jurisdiction that's not listed and you know it, I wouldn't mind if you send that, put that in the chat, because I would be glad to follow up with that afterwards to see what other states are doing as well. But again, I just want to be clear. My point here is not to give a comprehensive, this is not as if I've already done a full-blown study on all 50 states. This is really trying to give a flavor of what some of the issues are. And I'm going to use just a few states of examples because I looked at some of the language, and I think that helps sort of clarify a couple of things. It's going to help us clarify what is it that the states are asking from the forensic evaluators, okay? And it also raises questions about, which I'll get to at the very end, like what can we all do as advocates if there is an attempt to try and change the law? What is it we can do to try and make sure that it is changed in a way that's appropriate and that makes sense, both in terms of ability to do the evaluations and the needs and rights of the individual? So let's take New York, for example. In 2012, their procedures were modified to allow for outpatient competency restoration in lieu of hospitalization for restoration. Now, let me just also be clear, I happen to know that there is a lawsuit being filed right now against New York State claiming they really haven't done this. They put it in statute, but haven't really implemented a robust outpatient competency restoration. But again, that's beyond the scope today. and their considerations. There's actually guidelines given to from the Department of Mental Health, or I think it's the Office of Mental Health is what it's called in New York. Here are some considerations for when somebody should go into a hospital versus outpatient. The first is the obvious one: dangerousness to self or others associated with mental illness, right? Basically, commitment criteria or protective factors. It's always the opposite too, right? In other words, are there protective factors that indicate this person does not need hospitalization but can be adequately treated and restored in the community? Stability in the community, stable housing, other community supports. And again, we're not going to get into that today, but stable housing, of course, everyone understands is easier said than done with large populations of individuals who are unhoused. So in principle, that's right. In practice, it's much more difficult. Substance use is an issue because obviously if somebody's substance use is impacting their mental illness, if you're in a hospital, there's more ability to prevent that. Once they're in the community, that's going to be more difficult. And then there's just a common sense issue. If the person has serious medical needs that cannot be managed in the community, they're going to require hospitalization. So this is an example, again, of another state where they've laid out what some of the guidelines should be for whether somebody is sent for an inpatient or not. And this is something that is on the forensic evaluator to weigh in on, okay? Right, okay. Another state, as an example, Virginia, okay? They're basically saying when the evaluator does the competency evaluation, you see it's bold on the bottom, if a need for restoration is identified, the report shall state whether inpatient or outpatient treatment, community-based or jail-based, is recommended, okay? Ohio, similarly, the examiner's recommendation as the least restrictive placement or commitment alternative. Okay, so these are just examples. I haven't done all of them, obviously, but the point is that the more and more states are saying to the forensic evaluators, let alone, all the systems issues involved, I want you to weigh in on whether or not this person not only is incompetent to stand trial, but if so, do they need inpatient hospitalization for restoration, or can it be managed elsewhere? Now, this has generated some opposition, including from forensic evaluators, and I'm assuming, given the number of evaluators here, some of you are on this list, and feel free to put it in the chat, the questions and answers, we'll get to that, the Q&A. But what are some of the most common issues raised in opposition? One of them is, hey, this was beyond the scope. I was asked to do a competence evaluation. Whether or not the person needs inpatient, what their treatment needs are, is beyond the scope of what we've been asked to do by statute. Second one is, well, we're really stretched thin in terms of how much time we have to devote. This will add a lot of extra time to our evaluations. I don't have the resource to be able to do it. A third one is, okay, if you're asking me to recommend whether or not somebody is appropriate for existing outpatient programs, but I'm not familiar enough with all of the programs. And this is especially true in states that have a centralized system, right? Massachusetts, for example, is done at the local court. So there's a lot of connectivity between the forensic evaluator and local resources. If you're doing it statewide, can't possibly be expected to know about the resources in every county in your state. So those are some of the issues that have been raised. And let me offer some of the rejoinders, but also some support for the legitimacy of some issues. The first one is actually pretty simple because it was beyond the scope, but once the statute is changed, it no longer is. I mean, and that's what's happened in states. They've actually changed the statute to say this is part of the evaluation. When you there'll be detailed information. In this state, the statute will say when you complete a competency evaluation, you also need to opine on X, Y, and Z. And we'll get back to some of the specifics of that as well. The other one is the constraints, that it adds a whole lot of time. So first, I want to just be clear about something. A triage decision. And again, I know I'm going to hear, and I agree, that not all the states we're going to talk about are asking for triage. Some are asking for a lot more. And I think that is a more complicated issue. But many of these, like the ones I had examples of, are triage decisions. Basically, is there enough information based on the factors that have been elucidated to suggest that this is somebody who should be in an inpatient versus outpatient? Again, it doesn't require a full risk assessment in most jurisdictions because there are clinical factors as well that can be used. Clinicians in ERs, crisis clinics, do this daily in a short time frame. Any of you, I'm sure there are people here who have worked in those settings. It's often a very quick, somebody's brought into the ER, you don't have a lot of time to do an evaluation, you don't have a lot of other background information, and yet on a routine basis, a decision is made, this person really needs to be admitted, at least initially, to an inpatient facility. And I will tell you that in Massachusetts, we've been doing, even before this case that I mentioned, we've been doing it for years. Every time you do a forensic evaluation at the court clinic, you are supposed to recommend to the judge whether or not the person should go into the state hospital for further evaluation or whether they can be further evaluated in the community. It has not been controversial. People have been doing a really good job of it. So it is doable, and it doesn't add on necessarily, it's not hours of extra work. It may be a short amount of extra work, but it is all doable. And Massachusetts, just one example, I can talk to it because that's where I worked for many years, but I'm sure people in other jurisdictions here can talk about their experiences as well. Lack of familiarity is absolutely an issue. And this really is more of a systemic solution is required. So what a number of states have been doing is they have employing what they call forensic navigators. These are individuals, I think Henry Stedman many years ago coined the term boundary spanner. This is somebody who works within the mental health system and the criminal justice system to help the courts to identify here are the programs. This person was referred for this program. Here. This person was referred rather for outpatient treatment. Here's where the person can go. Here are some of the issues involved, et cetera. So this is I think, a legitimate issue that requires the states to not just ask the evaluators to come up with where you're going to send this person, but the state has to develop the appropriate programs, and they have to have someone else besides the evaluator to provide guidance about which programs are available, which have beds, et cetera, et cetera. It doesn't do any good to say you're going to an outpatient competency restoration and then the program says, but our beds are full. Somebody has to be tracking that. So this is a legitimate issue in terms of resource, but it doesn't mean that the evaluator can't at least opine on whether or not the person would be suitable for outpatient treatment restoration. Now I'm going to give you some examples of that some of my colleagues have sent me of different states and some of the language. Arizona says that the report should also include the prognosis, including the most appropriate form and place of treatment based on the defendant's therapeutic needs and potential threat to public safety. So I'm not from Arizona, so I don't know how people do this, but I will say at least the language potential threat to public safety seems way broader than some of the other states, which were very clear that does the person pose a risk due to mental illness? This feels a lot broader than that. And that's something that I think really should be taken into consideration about how people deal with language like this. Okay. And they're also asking whether or not the defendant is incompetent to refuse treatment and should be subject to involuntary treatment. I'm going to come back to that from some other states, because again, I don't know how comprehensive Arizona wants this, but obviously if this were a full-blown competence to make treatment decisions and subject to involuntary treatment, that this goes well beyond just whether the person needs inpatient treatment, but whether or not they should get involuntary medication. And as we'll see in a couple of other states as well, this causes real issues potentially if it's not done properly for psychologists as opposed to psychiatrists. And then New Mexico, and obviously I see Randy is here now. Anyway, from New Mexico, can pipe up when we get to the end. But I was sent this to say, New Mexico has recently changed their statute, and the forensic evaluator has to opine on criteria for involuntary commitment due to mental disorder. Okay. So at least this, as opposed to Arizona, does require mental disorder. This feels like more than a triage, right? It's criteria for involuntary commitment. There's also a requirement to address whether the person satisfied the criteria for involuntary treatment in AOT, assisted outpatient treatment, which also seems a little broader than what we have in other states. And they also specify, primary diagnosis, is unlikely to participate, is in need of outpatient treatment as a least restrictive alternative. Again, this language seems a lot broader to me than it does in other states. So I really would defer to colleagues in New Mexico how they're going about actually addressing this in a reasonable manner. Wisconsin has an interesting language that the examiner should provide an opinion whether treatment in an inpatient or in a community-based treatment program or in a jail. And I only highlight the in a jail because I think, as I've mentioned, jail-based competency restoration is being used in many jurisdictions. And there are a lot of advantages. If you can't get somebody into a hospital and they're sitting in jail, obviously trying to do restoration while they're there anyway is a real laudable goal. On the other hand, there's some concerns that being in a jail, if that's the alternative, really takes away the incentive to find more appropriate placements. But it also, I just don't know, if people from Wisconsin could pipe up, I don't know under what circumstances a forensic evaluator would opine that jail is the most appropriate treatment versus one of the other two. Okay, so let's look at this more broadly. What is it that forensic evaluators in this new environment are being asked to do in competency evaluations? One of them, at risk, you have to go beyond just competency. Does this person pose a risk of harm? Is one of the criteria, not the only one. But again, there's no need to do a full risk assessment in most jurisdictions, especially if all you're being asked for is a triage. Okay. If you ask for a triage decision, this is something that has been done in many jurisdictions for quite a few years without a problem. If you're being asked for, if you're being asked for a full-blown opinion on committability, and I also have to say a lot of this depends on how the systems operate. Is there a contested hearing where you get cross-examined? I wouldn't want to be cross-examined on a 15-minute evaluation to say somebody needs to be involuntarily committed. So what else needs to be taken into consideration in all these jurisdictions is what is the process to go from the opinion by the evaluator or the recommendation to actually coming up with an actual judicial order. The clinical considerations that I think we're all used to doing all the time in all sorts of settings are the acuity of symptoms, a relationship of their symptoms to violence or self-harm based on their current presentation as well as their history. And obviously we don't always know history. So that's a caveat here, is that you do the best you can based on the information that's available to you. Amenability to treatment. And by the way, what I'm leaving out here, just because it would take us too far afield, is that there's also a whole issue of individuals who are not likely to ever be restored. And if they are sent into an inpatient facility, they're taking up a bed of somebody who really needs it. So that's a separate issue. It's a little bit beyond the scope here to get into that. For the purposes of this presentation, let's focus only on those cases where we think somebody is amenable to treatment. It's really a question of where they can go. What are you basing it on? What are they currently stating? What are they currently doing? If they're in the jail, evaluators should be getting the mental health records from jails. And again, I know that in some jurisdictions, people say, oh, I can't, the jail, they won't release them without a court order or without a release of information. That's a systemic issue that I think really falls on higher level administrators to go to the legislature, to the judiciary, to try and figure out how can you really make sure that if you're asking an evaluator to answer these questions, you make sure that the evaluator has access to the relevant information and data from mental health records, particularly in jail, where if that's where you're doing the evaluation, are essential. Any known history, again, I understand the caveat. If you don't know, you don't know. But if you do know, is there a history of treatment adherence, non-adherence in the community? Are there any collateral informants? Sometimes there are, sometimes there are not. The other issue is stability, the person's stability. Are they domiciled? Because obviously, if they are, and they may have a support system, either lay or professional, that may give you more confidence to think this is somebody who can be restored in the community. If they're not, it doesn't mean that you can't recommend somebody who is is unhoused, that you can't ever say they can be in the community. It just means it's a consideration to take into effect as to, like, will they be able to maintain stability in that environment? Are they using substances, and is that exacerbating their symptoms? These are all clinical factors, okay? So I want to sort of stop there for a little bit of a summary, which is to say, okay, there are a number of factors that we as clinicians can take into account and answer some of these questions. However, as you saw, some of those statutes, and again, I didn't go through all of them, include elements that are likely to be difficult to assess within the time constraints of brief assessments. And some of them ask for a more definitive opinion on commitment or on assisted outpatient treatment and or involuntary medication, which may really tax the resources of and the ability of a forensic evaluator to answer those questions at the level that is required. I don't have much more to say about that because I don't know how it's working in jurisdictions that I don't work in. I could tell you, at least in Massachusetts, we're not asked to do all that. But I think if you are asked, this becomes an issue for both forensic psychologists, your professional organizations, the state agencies, to try and figure out how can we provide the court with the relevant information in an ethical and professional way. And I think that's sort of another overarching point that I'd like to make, is that it is really important to have representation when statutes and guidelines are developed. Okay. I see some of these state laws and I do wonder at times, like, well, who was at the table? Were the relevant parties people who are experienced in doing these evaluations, people who are high-level administrators with the offices of mental health, departments of mental health? To what extent are they involved in helping to craft the language of the legislation? Because some of this language really does seem like it's not as carefully worded, if I can say that, as it should be. And one of the ways to deal with that is to make sure that knowledgeable people are at the table when all this is being done. Okay, let me also talk a little bit, just sort of, again, wrapping up, about the role of forensic evaluators in all this. So just again, the role of forensic evaluator is expanding. It is not the way many of us were trained many years ago. I guess for the newer folks here, maybe this is all you know, but for people who've been doing this for many years, this is a very different landscape than it was when we started doing this years ago. We're being asked to recommend placement, inpatient or outpatient, okay? This may include a triage assessment tied to mental illness, but we really should be leaving general risk issues to the court, the legal system. It's not our role to say whether this person may be a risk due to factors other than mental illness. That's something that the court should be doing. Some states have dangerousness hearings. I mean, there are various ways they can do that. It's up to the lawyers and the judge. Our job is not to say whether this person is dangerous. It's rather, do they pose a risk due to mental illness, or do they have clinical needs that require inpatient? And this one I just want to talk a little bit about, because evaluators in some jurisdictions, like California, are asked to opine about the need for involuntary administration of antipsychotics. Okay, well, if you're a psychiatrist, I mean, again, within the confines of how long it takes, but assuming you have the time, the resource, and you have the data, that makes sense. What if you're a psychologist? Okay, I will say, without getting into great detail, that California really does have a good system. They have in their statute different requirements for psychologists versus psychiatrists. And the language for psychologists, I think, is well crafted. It basically says, does this person have a disorder that I can't remember the exact wording, is likely to or typically responds to antipsychotic medication? Well, that's something we can say, right? As psychologists, we can say, yeah, the person is diagnosed with schizophrenia, bipolar disorder, 1, 2, major depression, whatever. And we know, well, we're mostly talking about antipsychotics, so it would probably be really only the psychotic disorders and the bipolar. But we can say, yes, this person does have a disorder that is typically treated with antipsychotics, and the psychologists in California are not being asked to opine whether they should actually therefore be involuntarily medicated. That is left for another stage for a psychiatrist or an MD. So I think that's very important to understand, is that even when psychologists are asked this, there needs to be a clearly defined role and a limit to what we can offer. Here are some caveats. As I said at the beginning, despite the fact that this is role expansion, our role is still impartial. Okay, we are not advocates for the individual per se. And it's important to understand that, because we are opining on clinical need for treatment, but that is something you can do objectively, impartially. Again, we do this all the time. Those of us who are involved in civil commitment evaluations, in whether insanity acquittees can be released into the community or need to be still need to be committed, whether they are appropriate for conditional release. This is something that we've been doing for years and years, and you can do that without being an advocate. You can still do that impartially and say, here are all the data that I have that move me in this direction or the other. But I think we need to acknowledge that there is a subtle shift that is not just going beyond assessing competency and opining on whether the person may be more appropriate for inpatient versus outpatient setting, but it's the increased pressure is because there is a real interest, and a legitimate one, in removing severely mental individuals from jails. The harms, I mean, again, I hopefully I'm just preaching to the choir here. We all know this. That's why states are being sued. So many states are being sued because they're letting people languish in jail with severe mental illness, who a judge has said needs to be in an inpatient hospital or needs to be restored to competency, and they don't have the resources to do it. So there's legitimate desire on the part of the states to come up with some mechanism to say, how can we limit the harm that is being done to mentally ill individuals who are languishing in jail who really need treatment? Okay. On the other hand, and I guess that's sort of the main point of this talk, is there are ways we can do that that are consistent with our standards of practice, that are consistent with our ethics, and we need to make sure to create the right boundaries around this. Say, here's what we can do, here's what we can't do, okay? And to work with the relevant stakeholders to figure out how can we make this system work better, okay? Again, I could tell you from personal experience, I was in Massachusetts for, I don't know, I think 36 years or so, working in that system. I can tell you that the evaluators at the court clinic doing these triage evaluations did a great job of deciding who really needed inpatient treatment and who didn't. In fact, I worked on both ends. I started my career working in the court clinics. I ended up overseeing services in a inpatient forensic hospital. And I was always struck by how infrequent it was that we'd get somebody sent into our hospital for treatment, and we would say, oh, this person really wasn't incompetent. This person didn't need further evaluation. Well, let me just qualify that. It doesn't mean, it's fair to say that the person may have been competent, but that usually it was like, well, the person may be competent, but it requires more work to determine that than they could possibly do on an outpatient basis. If there's a question of malingering, we always thought, yes, it's most appropriate to have them in an inpatient facility that we can we can observe them over time. And I want to end because I want to leave about 10 minutes for questions. I just want to end with one of my favorite examples of why it's important to have sort of a more intense observational system for somebody who you think is malingering, rather than just asking them questions or giving them a SIRS or a SIMS or whatever in a court setting. And this was an individual who was charged with a pretty serious crime. And whenever I came to interview him, he would basically just mumble and talk nonsensically, and it made no sense at all. And he got a psychiatrist to come and evaluate him and said, "Oh, he's grossly psychotic." And I'd look at him and say, "I know that this isn't legit." The problem was like, okay, well, I say it's not legit. He says it is. What can you do? He was in an inpatient setting, and I was able to review the notes of the inpatient setting. And one of them was great because right before the person came into my interview, there was a note that said playing chess with other patients. And it's like, all right, that's pretty good. So I actually eventually testified to that. The person was found competent. I will say he had a very good lawyer, because the lawyer asked me the best question I've ever been asked on the witness stand. I said, "It says he was playing chess." And he said, "Does it say he was playing by the rules?" I thought that was very clever, but the judge didn't buy it, and the person was found competent. Anyway, the point of that anecdote is simply that there are times when it is appropriate to have a person in an inpatient setting, even if they're not definitely acutely psychotic, either because malingering, but sometimes it's really just complex clinical conditions that really need to be teased apart. And that's a lot more easily done in an inpatient setting than in an outpatient. So I'm going to wait, and then you're all going to get or have access to this PowerPoint. And so there are some selected references here. A lot of them are from my colleagues who have done a lot of this work. And then there's also a evaluation link or CR code, although I assume there's some other way for you to get that because I'm about to stop sharing. Okay, so with that, Randy, I see you there. If there are questions in the Q&A, I'd be glad to take them.
Good morning and good afternoon, Dr. Packer, depending on where our listeners are. It's been a complicated morning for me. First, I was at the fire department, and then we had a fire alarm, and my internet is unstable, so sometimes I could not hear you. But thank you for the comprehensive talk. I'll try to manage getting some questions to you. What are your thoughts on recommending the defendant receives court-ordered medication in the jail rather than recommending competence restoration treatment for those defendants whose medication noncompliance is the primary barrier to competence? That is, if they get the medication, they're likely to be restored to medication. They really don't need to learn about what a judge, lawyer, public defender, guilty or not guilty means.
Okay, great question. So first of all, let me just say the education part of competence to stand trial is something, one of my pet peeves is that there's so much focus on that. There are very few, I mean, I've done this for 40 something years, right? Unless somebody has intellectual disability, we're not talking about that, or, brain injury. Most of the time, what's causing their incompetence is a psychosis, is need for mental health treatment. So what should be happening in the hospital is not focused just on education. Obviously, you need to do that for those who need it. It's just more intense treatment. I'm a little nervous about an evaluator saying, hey, yeah, the person really does need psychiatric treatment, but I think they're better off getting it in a jail than in a hospital. I don't really know under what circumstances it's better for somebody to get treatment in jail than in a hospital. And I think those who have worked in inpatient settings know that treatment goes well beyond just giving them medication. So there's a milieu, there's all sorts of other stuff going on to help that person acclimate. Jails are harsh environments. So I'm reluctant. I'm not saying people can't do it, but I would be reluctant to say, sure, they just need medication, might as well keep them in the jail rather than put them in a clinical setting.
Okay. I'll provide a follow-up as long as you talked about this issue. Are you aware of the percentage of in-jail treatment programs that include A, medication as a component, and B, medication over objection as a component?
I actually know, at least in California, there is a mechanism for that. I don't know about other states. In Massachusetts, I know the jails are extremely reluctant to do that. So yes, no, I don't know the answer. Do you? Are you asking me because you know?
No, no,
Oh, sorry. I know. I thought maybe
no,
you
I'm
had the
not
answer.
asking.
Yeah.
This is not Stump Randy.
No, I didn't think it was
Okay.
stump. I thought maybe, hey, did I know some that you didn't know? But no, I really, I mean, I know that in California, there is a mechanism to try and get involuntary treatment. I will tell you that they typically, I know that I just did some tours of jails in a couple of counties there. And I know they try to use that not for incompetent offenders even, but these are people who go to the hospital, are restored to competency, come back to jail. Then they stop taking their meds and then they deteriorate. And somebody here from California will even know the number. There's a statute that allows them to ask for that. So I'm all in favor of that, but I'm just sort of reluctant to say that if you think the person needs inpatient treatment or psychiatric treatment, that the best place to do it is jail. Jail may be the alternative. The bed count. I mean, I don't want to mention states that are in lawsuits, but somebody's waiting 6 months a year to get into a state hospital. I would much rather they get the treatment in the jail than just wait there and deteriorate. But I don't know how many jails genuinely are comfortable with doing involuntary medication.
Yeah. Okay. Next question. How do evaluators take into consideration whether the court would remove the bond or release the defendant if the examiner is recommending outpatient restoration? How do you take into account the custody matter?
I actually think that's not our role. Our role is to say to the court, look, we think this person can be treated in an outpatient setting, and we think they can be treated safely and effectively in an outpatient setting. It's then up to the lawyers to argue whether or not the person should be released. Many states don't even have cash bond anymore, but they need to make that decision. And I'll give you a very simple example. Many years ago, with my groundswell colleagues, we consulted to LA County Office of Diversion and Rehabilitation, and they asked us to go into the LA County Jail, which is the largest mental health facility, Twin Towers, probably in the country, if not the world. There's like there were several thousand mentally ill people there. And just to identify who might be appropriate for outpatient treatment, okay, or diversion. It was actually diversion. But they broke us up into two groups. They had the clinicians say, what are the clinical variables? And then they hired some lawyers and legal scholars, and legal academics, and they went to look and say, okay, what are the factors that might make this a good case to argue that the person should be released from custody by the sheriff on bail or on recognizance? So I think we can't presuppose that. I think we need to just say, do you think this person is appropriate for treatment in the community? If so, I'm going to leave it up to the judicial system to decide if there are other reasons why you don't want to release him or her.
Okay. All right. So this is a question. So our dilemma here is that often we have someone who needs inpatient treatment, in our opinion, but the wait list is well over 20 days, so they will be held in jail waiting. Any solutions from other states or Dr. Packer?
Well, 20 days, you should be counting your lucky stars because many states, if they can get it down to 20, are going to be, hey. I mean, I will tell you that California, I think the Stiavetti lawsuit was like, I think 28 days, but they are way down now. They had been above. Texas, I can tell you, is way more. So, yes, what can you do about that? I mean, the truth is, one of the things is, and I would highly recommend anyone who's not in California to try and consult your colleagues in the California who are running the California mental health system. Kate Warburton, Melinda Ciro, who is a forensic psychologist, they have been amazingly creative. They've gotten their wait list down we started working with them, I think 3 or 4 years ago. It was 1900. They got it down to, last I heard, it was 350. And I don't know if it's where it is today, but they got it way down. One of the things they did was they put a lot of resource into providing acute services at the jail above and beyond what the jails provide. The second thing they did was they developed this reevaluation unit. They basically said, we're going to use our cadre of well-trained forensic psychologists. They're going to reevaluate them. The first couple of years, they basically found 30% had been restored to competency. Some of them because they had gotten treatment, some of them because they had been using meth. And once that got out of the system, they were no longer incompetent. And the interesting thing is, to their credit, all of a sudden they don't have enough work to do anymore because they're now getting these people out of jail so fast that they don't have time for the reevaluation. Yeah, Randy seemed to have disappeared.
I'm going to take off my video because you froze up on me. Maybe not others, but you froze up on me during that last stint there. Out of the possible strategies to mitigate this competence overflow, what do you think is the most feasible?
Feasible is an interesting question, but here's what I'm going to say. The sequential intercept model, right? Units and Griffin, that makes the most sense. The earlier you intervene in the process, the more bang for your buck. So obviously, the best way to prevent this overflow of incompetent defendants is to avoid them being put in jail in the first place, okay? Which either means diversion on the front end, better mental health services in the community even before then a lot of these people don't decompensate. If you have a bunch of mentally ill individuals who are in the community and not able to access treatment, it's not surprising that they not only deteriorate, but then they get arrested and then this whole cycle starts. So the earlier, the better. If they're already in the jail, then really enhance psychiatric treatment and psychological treatment on the front end as soon as possible. And some of those people are going to be restored to competency before they even need hospital level of care, or they may be improved to the point where now they are appropriate for outpatient. I mean, that's the other thing, right? Some of these people, after 10, 20 days of getting some treatment, may no longer be in need of inpatient hospitalization, and then they can be diverted into the community. So again, diversion, and especially if you can do it before they even get into the system, but the earliest you can do diversion is best. If you're a state that has long people in there for more than 30, 40 days, I really do think a reeval unit is a great idea. And Melinda DeCiro is the person to talk to because she's run that system in California to great effect.
All right. We're at the top of the hour, so feel free to sign off if you need to as an attendee and get your credits or whatever else. Dr. Packer, are you willing
I'm
to take
free.
that?
I'm
Okay.
as you know, Randy, I'm semi-retired, so
Yeah.
I've got
All
lots
right.
of time. Yes,
So
I really have. I could take questions for another 5
we'll
minutes or
do.
so if people have, because
Okay.
I'm assuming
How,
there are.
so the people who need to sign off those who are interested will remain. How can psychologists and other mental health professionals become more involved in these conversations regarding creating statutes that are responsive to and can help manage the problems?
Great question. So obviously, the people who really need to be at the table are the leadership of the departments of mental health, behavioral health, whatever they're called in the state. Those people need to be there. The people who work in the forensic system need to be part of that as well. And many of those either work with, as part of the state, or they're contracted with the state. So they should be able to get to the table. But you also have state psychological associations. Now, and this is really not a criticism, but I know that the problem is if you're a state psychological association, the vast majority of your members don't know much about this issue. This is not really their bread and butter, but I still think that they usually have legislative liaisons. They have, I worked with Mass Psychological, so I was on the board of Mass Psychological many years ago, and I know that they have good legislative contacts. So I think the state psychological associations and certainly the state agencies involved, and even with the state agencies, it shouldn't just be administrators, should be administrators plus clinicians. Did I lose you?
Again, you froze up on me. I think this is my problem, probably not your. Real quickly, someone wrote, I was frozen when you made reference to, did you make a reference to SEL, SELL?
No,
Because someone here
nope.
has SEL versus question mark, SEL versus US.
Yeah, I know
I
the
can't,
case, but I didn't reference it. Yeah,
oh, so someone just wrote SEL versus question mark. If they're looking for the other party, it's the United States of America. I can't remember the year if they're, or maybe they're suggesting that SEL was relevant to something you were saying. In actuality, we don't have any more questions, I would say.
right,
Some helpful commentary and all of that, and some very interesting observations. So given my fear that I'm gonna get frozen out again, we're at 5 minutes after the hour. Dr.
great.
Packer, I wanna really thank you for your comprehensive summary and evaluation today, and remind others that if my schedule is right, if you liked this talk this week, you'll like next week's presentation, where we have a group of professionals from the Washington Office of Forensic Mental Health Services discussing competence to stand trial evaluations in Washington in the face of federal litigation that's been going on there. Dr. Packer, you might have some independent knowledge or experience in that matter as well, but
Yeah, we worked with them many years ago. Yeah, but let me,
yeah.
can I just ask the comments that are in the chat, are you able to copy and paste them and send any
I'll
to me, or is it going to disappear? They
Yeah,
can
yeah,
disappear as soon as you
I
hang
will
up, right?
try. Alex, if you're with us, can you help Dr. Packer on that? Because I think there's some information in there that he would like to get his hands on.
Absolutely. Yeah.
Continues to study these matters.
Absolutely. Yeah, I'll send those to you,
Okay,
Dr.
Alex.
once we sign off here.
Okay.
Thank
And
you.
to again, Dr. Packer, thanks so much. Good to catch up with you, and everyone who participated. Thanks for coming, and hope to see you next week when we talk about True Blood in the state of Washington. Until then, goodbye.
Bye-bye.